5 seconds. Ready, start. I have heard learned counsel for the parties and gone through the record stop. As there is no argument raised on behalf of learned counsel for the appellant as regards the issue of execution of the agreement in question, therefore the same is not required to be dealt with in this case. As such, findings recorded by both the courts below in this regard has to remain undisturbed, consequently upheld. Stop. Now the only question which the accuracy and integrity of this document survives in the present appeal is about the readiness and willingness of the respondent plaintiff so as to perform his part of the agreement in question. Stop. Readiness and willingness has been expounded upon by the Honorable Supreme Court in judgments titled as His Holiness Acharya Swami Ganesh Das Ji versus Sitaram Thapar AIR 1996 SC 2095, and it has been held that readiness means the capacity of the plaintiff to perform his part of contract, which includes his financial position to pay the purchase price, and the willingness to perform his part of the contract which relates to his conduct. Stop. There is a distinction between readiness to perform the contract and willingness to perform the contract. Stop. By readiness may be meant the capacity of the plaintiff to perform the contract, which includes his financial position to pay the purchase price. Stop. For determining his willingness to perform his part of the contract, the conduct has to be properly scrutinized. Stop. There is no documentary proof that the plaintiff had ever funds to pay the balance of consideration. Stop. Assuming that he had the funds, he has to prove his willingness to perform his part of the contract. Stop. According to the terms of the agreement, the plaintiff was to supply the draft sale deed to the defendant within the 7 days of the execution of the agreement by 27 February 1975. Stop. The draft sale deed was not returned after being duly approved by the petitioner. Stop. The factum of readiness and willingness to perform plaintiff's part of the contract is to be adjudged with reference to the conduct of the party and the attending circumstances. Stop. The court may infer from the facts and circumstances whether the plaintiff was ready and willing to perform his part of the contract. Stop. The words ready and willing imply that the person was prepared to carry out the terms of the contract. Stop. The distinction between readiness and willingness is that the former refers to financial capacity and the latter to the conduct of the plaintiff wanting performance. Stop. Generally, readiness is backed by willingness. Stop. Over.